Hello, I'm George from Ireland. So, welcome back to the English Law channel. So, I'm continuing with contract law and talking about method of acceptance. So, how do you accept a contract? What do you have to do? So, sometimes the offerer says this is the methods you need to use to accept the contract, and only that shall suffice. There was Manchester Diocesan Council for Education against Commercial and General Investments 1970, which is a leading case on that particular question. Now, sometimes the way that the acceptance is supposed to be communicated can be deduced from the way the offer was made. And there's Quena Duane against Cull 1883, which is a case about that. Now, this gets tricky if the offeree uses a method of acceptance which the offeror didn't want. We have to ask, is that a proper acceptance or not? So long as this method does not disadvantage the offeror, then it's a proper acceptance. But sometimes the offeror might say you must use a particular method and only that method will do. So Manchester Diocesan Council for Education, that's the case about that one. Okay, so what if an offer is not accepted? Well, you might make an offer, an open offer with no time limit on it, but that does expire after a reasonable time. What's a reasonable time? That defies any simple answer. Is it a month, a year, a decade, or what? It would depend on the nature of the offer and what is being offered for sale and for how long and so on. Okay, how about if somebody has a change of heart about the whole issue? So, if you make an offer, you have the right to withdraw that at any moment. So either party can change his mind and pull out of parleying about this contract. Payne and Cave 1789 is about that one. So sometimes the offerer said that the offer is going to be open for a stated length of time. However, if he decides he wishes to withdraw that offer before the deadline, then he has the right to do so. Unless, of course, there's a separate binding collateral contract which says that he can't withdraw it before that time. Routledge against Grant 1828 is a case about that. Okay, so there's you can revoke your offer, but to be affected, this must be communicated. Byrne against Van Tienhoven in 1880 was a case about that. Notice that you don't need the revocation doesn't need to be communicated with the offerer. The communication to the offeree can be through another person. Dickinson against Dodds 1876 was a case about that. So unilateral contracts are very thorny, and that's because the thing that stipulated acceptance of a unilateral offer might take some time to do. Making an offer to all the world to do whatever it is, don't have to tell me you accept the offer, just go and do it and then inform me. So a situation could occur where an offerer wants to revoke this unilateral offer. The offeree has already started to perform the contract. So it might seem unfair for the offer to be withdrawn in such a situation. Anyway, Errington and Errington 1852 is a case about that, or Salisbury against Salisbury 2007. But the revocation is usually held not to operate. You made a unilateral offer, then someone started performing, you revoke the offer not knowing somebody's already performed the contract. Sorry, you can't do that. The offer was accepted and you're going to have to pay out on it. In Luxor Eastbourne Limited against Cooper 1841, the House of Lords ruled on this. They said the revocation of unilateral offer after the offeree has started to perform is usually impossible because there's an implied term that the offeree shan't revoke the offer. So once somebody has actually started to perform the contract. Dowley against Flower Millbank Nominees 1978 is another case about that. So there's an implied term there to give it business efficacy that you can't withdraw it after someone's already started to perform. Now, this does depend somewhat. If the person, the offeree, has done only a tiny bit of work for it, then that might be acceptable, revoking it. How much is tiny? Again, that's imponderable. There are no hard and fast rules on that one. Okay, so what else do we talk about? So there are different issues which arise when an offeree changes his mind. For instance, supposing the offeree posts a letter of acceptance, then the offeree says, actually, I don't want to do that, and uses a faster method to tell the offerer, no, actually, I don't want to accept the contract. So, what takes precedence here? Does the postal acceptance rule operate as in the moment it's posted, it is received? That's the sort of the fiction we go by, or can the postal acceptance rule be trumped by actual communication on the phone, which is instant? So English law doesn't provide a clear answer to this, but Scots law does. There's Countess of Dunmore against Alexander, 1830, is about hiring a servant for a house and something like that, and don't need it after all. And they found that if you use that faster method of communication, then the postal acceptance rule doesn't operate. Or Wankheim against Arndt, 1878. So that's a New Zealand case. So anyway, remember, those aren't binding in England, they are persuasive. Okay, so what if a condition is not fulfilled, a condition the offer? Well, that means that the offer is over. So the offer might be subject to a certain proviso, and if that condition isn't satisfied, then the offer terminates. So the condition there is implied. Financing Limited against Stimson's 1962 is a case about that. Okay, now how about if the Grim Reaper intervenes? Well, supposing the offeror or the offeree feels the icy hand of death upon him, then the offer will lapse. There's Bradbury against Morgan, 1862. But bizarrely, this is a bit different. The offerer's estate was held to be bound by the offer, even after the death of the offeror, although they wouldn't usually do that now. In Obiter Dicta in Dickinson against Dodds, 1876, it said that the death of either the offerer or the offeree ends the contract because there's no agreement. So now we would say that really a party cannot accept an offer if he's found out that the offeror has died, right? Okay, so the death of offeree would usually terminate the acceptance of an offer. All right, how about lapse of an offer? Remember that it lapses after a certain time, even if not specified. Offered against Davies, 1862, about this. Okay, whatever's reasonable in the circumstances. Ramsgate Victoria Hotel against Montefiore, 1886, is about that, about the leader of Anglo Jewry, Moses Montefiore, the ancestor of goodness, what's his name? Sebag Montefiore, that famous historian. Okay, so there are lots of ordinary purchases and so on, which can be analysed as being contracts, buying things, or hiring services, so these are not really abstract. So there's offer and acceptance there, and there's communication when you're buying or selling things. Okay, so that's enough on offer and acceptance. Toodaloo.